Hey guys, David Tarras here, head of the Federal Criminal Defense Practice at the Rosson Law Firm. What we're going to talk about today is drug trafficking cases in federal court, and specifically minimum mandatory sentences that can come with a federal conviction for a drug trafficking crime, as well as the best ways around a minimum mandatory sentence. Here at the Rosson Law Firm, we have participated in the defense of some very high-level, very serious drug trafficking cases in federal court. Drug trafficking cases, perhaps of all cases, in the federal criminal justice system do carry some of the most severe penalties, and a lot of that relates to mandatory minimum sentencing. Mandatory minimum sentencing being either a 5 or a 10-year minimum amount of time that you must serve in prison, and that's day-for-day time. You get credit for the time you might have already spent in custody, but no programs, no reduction in sentence for good behavior, day for day, the whole entire time period. And whether or not your case has a mandatory minimum sentence depends on the drug quantity, drug type, and drug quantity, and as they relate to each other. Now, when we have a case that involves a mandatory minimum sentence, one thing we are always considering while we're fighting the case, preparing defenses, filing motions, is the possibility of a resolution to the case without trial. We would be remiss not to at least consider that. It may not be the right move. We may not be able to do so. You might have a great trial defense. We'll work that out with you as a team. But if you're considering, and if we as a team are considering resolving your case, and you have a minimum mandatory prison sentence that applies to your federal drug trafficking case, the big concept that we want to be aware of and that you need an expert attorney in is the concept of safety valve. Now, what the safety valve is in federal criminal court is a method for you to be sentenced if you are convicted or if you do plead guilty to a federal drug trafficking crime that does carry a minimum mandatory sentence. Safety valve is a way to avoid that minimum mandatory sentence. There are certain criteria that the defense must prove by a preponderance of the evidence in order to meet the criteria of a safety valve and for our client to be eligible to get rid of his minimum mandatory sentence, or min-man we call it in the profession, and to not have to face the potential of that very strict sentencing structure, giving the judge permission to sentence you within the guidelines or below the guidelines if we can successfully argue for a variance in your guideline that's ultimately calculated and applied in your case. The first requirement of the safety valve has to do with criminal history. Criminal history is an interesting one here. The law regarding what criminal history and how many criminal history points a person can have in order to still qualify for a safety valve is changing. It has changed. It changed with the First Step Act of 2018, and beginning in November of 2023, when the new 2023 United States sentencing guidelines are released, there's going to be a change to the way that the safety valve operates in the guidelines as well, specifically regarding criminal history. When you get a safety valve, if you judge and determines that you qualify for safety valve when you've had a phenomenal attorney argue for safety valve, if that's the route that we decide to go with your case and with your sentencing, once the judge approves that, the judge should, according to the law and according to the guidelines, give a automatic 2-point reduction in your guideline level. The change in the law is specifically related to that 2-point reduction in the guideline level. We have a big change coming, which is very favorable to the defense, which says that you can have more of a criminal history than previously in order to still qualify for safety valve, as well as a 2-point reduction. And also the way in which your criminal history for the purposes of safety valve is calculated is going to change. In the past, if you had more than one criminal history point, you were not eligible for safety valve. The First Step Act said that you can't have more than 4 total criminal history points. A 3-point prior offense, and 4-point not including 1-point offenses, 3-point prior offense, and a violent 2-point prior offense. As long as you don't have all 3, you qualify for safety valve. However, the guidelines had not yet caught up, and the guidelines still said that if you have any one of those, as opposed to needing to have all three in order to not qualify for safety valve. If you had any one of those, you're not entitled to an automatic 2-point reduction. Now, with the 2023 guidelines, that's changing. So if you have a drug trafficking case now, you want to make sure that your attorney, and hopefully it's us, that your attorney argues that that 2-point reduction that's coming in November 2023 is applied to your case and your sentencing now. And we've been able to successfully argue for that already. The other requirements of safety valve is that there's a nonviolent offense. Firearms was not involved in the relevant conduct of the federal drug trafficking. You must not have been a leader, manager, or organizer of the drug trafficking operation. That's a very important one, and that's something that we do argue very often, that our client was not a leader, manager, organizer, or supervisor. The drug trafficking offense, the relevant conduct of the offense, must not have resulted in substantial injury or death to anyone. We are seeing with the increase of fentanyl in the Southern District of Florida, where where our home base is here at the Rosson Law Firm and around the country, an increase in the amount of fentanyl trafficking cases that we deal with, very commonly involving overdoses. And that can be charged, and that is an enhancement you can face in your drug trafficking offense. So that must not have occurred in order to qualify. And then the last aspect, the last criteria that you are required to meet, that the defense is required to prove by a preponderance of the evidence in order for you to be safety valve eligible, is that you gave, prior to your sentencing, you gave a truthful account of your involvement in the drug trafficking offense to the federal government. Now, this is different than cooperation or substantial assistance. You don't have to make a case against someone else. You don't have to testify against someone else. You don't even have to talk about the other individuals in some cases that were involved in a potential conspiracy. The law says that you have to sit down with your attorney. We are always present with our client for these meetings if that's the route we want to go, and just be truthful about your involvement and your relevant conduct as it relates to the drug trafficking offense or the overall drug trafficking organization or conspiracy that you may have been involved in. So if you are under investigation for a federal drug trafficking offense, or you're currently seeking a prosecution and charges for a federal drug trafficking offense, please do not hesitate to contact the federal attorneys at the Rosson Law Firm. We can guide you through this process, and we are experts in achieving the best results, which in many cases may be to get you a safety valve and to knock out that minimum mandatory sentence. Thanks.